Good evening, all. Let me welcome to the 5 days Faculty Development Program on Entrepreneurship Education, Bridging Academia and Industry, organized by St. Thomas College of Engineering and Technology, Chengannur, in association with our IDC. Tonight, we'll explore more about the legal aspects of those which we have discussed in the last 3 to 4 days. May I call, may I take this opportunity to invite our beloved principal, Dr. Ajit Prabhu V, who has been instrumental in shaping the direction of our college and fostering a culture of research, innovation, and collaboration. Over to you, sir.
Yeah, respected chief guest of today, beloved Safiq, respected Dr. Vipin Gopan, Professor Abida, other my colleague faculty members, participating faculty members, a warm good evening to all of you. Today, in fact, we are coming to the fifth day, that is the end of this FDP program on innovation and entrepreneurship development, as you are aware. But today, like we say, last but not least, today we have got the one of the important aspect to be discussed, which is all the more important while building an entrepreneurship. Today we have with us a scholarly person, Mr. Safiq. Our relation is more than 22 years old. I know Safiq very much. We are that much close, family friends, and I always treat him as my younger brother. One of the important aspects I should highlight about Safiq is he's a self-made man, exceptionally brilliant engineer, has shown outstanding contributions in the field of intellectual property rights. And today I can say without any hesitation or doubt that he's one of the top authorities in the subject, that is intellectual property rights. Another aspect about Mr. Safiq is that, as you know, intellectual property right is a complicated subject, a technically hard subject, but he has a special acumen to make it very simple and digestible and make it very comprehensive. He has got a rich experience in this field. He has carried out a lot of patent search, delivered a number of talks on IPR. So we are fortunate today to have with us Mr. Safiq. I welcome Mr. Safiq, my beloved Safiq, to this FDP program. Safiq, welcome you.
Thank you, sir.
Today also, in fact, my
Mhm.
former colleague Dr. Binija is supposed to be with us due to some urgent preoccupation. She could not join, but I am sure probably in between she may join. I had just had a chat with her just half an hour before. I welcome Dr. Binija also, who will be joining, who expected to join us. Also, I welcome Dr. Vipin Gopan. He's the driving force. This whole FDP is actually his brainchild. And in the college, he is a star figure. He is an extraordinary professor doing so many things in the direction of innovation and entrepreneurship development. And with a lot of happiness and honor, welcome you, Dr. Vipin Gopan, to this FDP program. Also, I have so many affectionate colleagues in St. Thomas College, Professor Abida, who is comparing today, Master of Ceremony. Welcome you, Ms. Abida.
Thank you,
Also,
sir.
I take this opportunity to welcome all my colleague faculty members and also, most importantly, the delegates and faculty members from across the country. I understand that even from Delhi and even Tamil Nadu and neighboring states, faculty members have joined this program. So I welcome all of you to this important FTP program and today's important session. Once again, welcome you all and thank you.
Thank you, sir. Tonight, we have Mr. Shafiq S., Technical Officer, Technology Development and Project Management Division. Also, sir is associated with IPRIC, Intellectual Property Rights Information Center, Kerala, and also which is a nodal agency of Kerala State for all IPR related matters. Tonight, we'll explore more about the legal aspects of all those topics which we have discussed in the last 3 to 4 days. So, sir is an expert in the same. Over to you, Shafiq, sir.
Thank you. Am I audible?
Yes, sir.
Respected Dr. Ajit Prabhu sir, Dr. Vipin Kovan sir, and other respected faculty members. So first of all, I express my sincere thanks to my Dr. Ajit Prabhu sir for giving me an opportunity to be a part of this faculty development program. Uh, Actually, I worked with him for around 17 years. I worked under him for 17 years. And whatever I learned about IPR and whatever I could do in this field is only because of sir's training, mentoring, and all the support which he has provided to me. So till now, we both handled several sessions on IPR for several institutions throughout the state, and this is the first time in which we are sitting on two different sides. So once again, I express my sincere thanks to Ajit sir for inviting me to this faculty development program and for giving me all the support throughout my career. So today we will be discussing about a very relevant topic, which was already mentioned by Ajit Prabhu sir, that is intellectual property rights. Is the slide visible?
Yes, sir.
Okay. So today we'll be discussing about a very relevant topic of the present time, that is intellectual property rights. Especially, you know that we are all living in the knowledge century, and we are moving towards the knowledge economy. So where knowledge and the intellectual resources will determine the economy of every nation. And intellectual property rights plays a major role in this knowledge-based economy because it is the legal tool to protect new inventions and creations. So it is very important that we all should be aware about the significance of intellectual property rights and the necessity of protecting our intellectual creations. So I'm sure that we are all well aware of the concept property, right? Especially the tangible property or the physical property which we have, which includes our movable properties as well as immovable properties. And we know how to legally protect these physical properties. If we have a tangible property or a physical property, we know how to legally claim that the property belongs to us. Similarly, there is another type of property which is basically intangible in nature. So such property are known as intellectual property. And today we will be discussing about this intangible property, that is intellectual property. So intellectual property is nothing but the property of human mind. Any intellectual activity which comes out from the human intellect is known as an intellectual property. It can be an invention, it can be a creative work, it can be a design, it can be a logo, it can be a symbol. So any intellectual activity which comes out from the human intellect is known as an intellectual property, that is IP. And if I am the owner of an intellectual property, I should have some legal rights to claim that that property belongs to me. So for that, we have got intellectual property rights. So if I am having an intellectual property, if I am having an invention, or if I am having a creative work, I should have some legal rights to claim that that property belongs to me. So for that, we have got intellectual property rights. So what intellectual property rights give us? It gives us exclusive right over our intellectual property for a limited period of time. And depending upon the type of the property which we are creating, we have got 8 forms of intellectual property rights. As per the TRIPS agreement, it's generally been considered as we are having 8 forms of intellectual property rights. We are having patents, then copyrights and related rights, trademarks and service marks, industrial designs, geographical indications, layout design of integrated circuits, protection of new plant varieties, and trade secrets. So these are the different forms of intellectual property rights depending upon the type of the property which we are creating. So in this session, we will be discussing about all these forms of intellectual property rights. So the first one is patents. We are very familiar with the term patent, right? Patent. So what patent protects? Patent protects inventions, new inventions or innovations. So inventions and innovations are protected by the intellectual property, which is known as patents. And what patent will give us? Patent will give us an exclusive right over our invention. If I invent something and if I am having a patent for that invention, I have the exclusive right to make that invention, to use that invention and sell that invention. And without my permission, nobody can do any of these activities. So it is the exclusive right which is being granted to the owner of the invention for a limited period of time. So that's why it is also known as a negative right, because I am having the exclusive right over my invention and I am having the full right to prevent others from using my invention. So that's why it is even, it's also known as a negative right, or even like a monopoly, like that it will be called. But it's basically an exclusive right to protect the inventions and innovations. And for getting a patent protection, the first mandatory thing is that we have to disclose it. If I am having an invention and if I want to get a patent for that invention, I should completely disclose my invention to the patent office. In exchange of that, the patent office will give me a patent right, which will be valid for a limited period of time. If I am not willing to disclose my invention, I will not get a patent, because patent rights are for a limited period of time, that is 20 years. So what happens till 20 years, I have the exclusive right over my invention. And what happens after 20 years? It will become a public property, so that anybody can make it, anybody can use it, anybody can modify it. Without my permission, anybody can do any of these activities. So for that, I have to completely disclose my invention. So disclosure of invention is mandatory for getting the patent protection. And another important aspect is that patent rights are territorial rights, which means if I am having an invention and I got a patent from the Indian Patent Office, that is, if I am having an Indian patent with me, that patent will be valid only within India, so that I can prevent a person in India who is copying my invention without my permission. But I cannot prevent a person who is copying my invention in any other country, maybe in our, even in our neighboring countries also. I am not able to do that because I am having only Indian patent. The validity of that patent will be within the geographical boundaries of that nation. That is very important. Patent rights are basically territorial in nature. And protection, as I said, it will be for a period of 20 years. That is the maximum term of protection of patent is 20 years. And after that, it cannot be renewed under any circumstances. So maximum term of protection is 20 years. And another important aspect is that discoveries are not patentable. Only inventions can be patented. Discoveries cannot be patented. You know the difference between an invention and a discovery. Invention or innovation can be patented, but discoveries are not patentable as per the Indian Patent Act. And the patenting system in India is followed by the Indian Patent Act 1970. So the entire patent system is governed by the Indian Patent Act 1970, which was amended again in 1999, 2002, and 2005. So the basic act is the Indian Patent Act 1970, which is supported by the Patent Rules 1972. So we are having both act, which is complemented by rules also. So we are having the Indian Patent Act 1970 supported by the Patent Rules 1972. And these rules has been amended many times, nearly 15 times it has been amended to add more and more provisions, to give more and more provisions into that act. These patent rules has been amended right from 2003 to even 2024. So many times it has been amended. So we are having the Indian Patent Act 1970 and the Patent Rules 1972. Then, as I said, patent protects inventions or innovations. So the definition of invention as per the Indian Patent Act is invention means it should be either a new product or a new process involving an inventive step and capable of industrial application. That means the invention should either be a product or a process. So that is the definition of invention. Okay. So for an invention to be eligible for getting a patent protection, we have a patentability criteria. We have got three criteria for getting the patent protection, which includes novelty, non-obviousness or inventive step, and industrial application. We will see one by one. First one is novelty. What is novelty? Novelty means the invention should be new. New means it should not be published anywhere, it should not be used anywhere, it should not be patented anywhere, it should not be in prior public knowledge anywhere before the filing of patent. So if you're having an invention and if your invention has to pass the criteria of novelty, it should not be published anywhere, it should not be used anywhere, it should not be patented anywhere. Till the filing of patent, the invention should be new. Okay, then only it will pass the criteria of novelty. So this is where the problem comes, especially in the engineering colleges. We have been witnessing this for quite a long time, because as part of the academic projects, the students will be doing some project works, and some of them might be potential projects also. So what happens is that due to the lack of awareness about the patents as well as the patentability criteria, what they will do is that they publish their invention in the newspaper as well as in the media. Okay, so what happens is that once the technical details of the invention is disclosed, it is published before filing the patent, then you cannot get a patent for that, because the novelty clause, that novelty condition has been it will not be satisfied. So this is where the role of faculty members come, because you can guide your students, you can advise them that if they are having some innovative work, don't publish it anywhere before filing the patent application, because once the invention gets, even if I am publishing my own invention, then also the novelty will be lost. So once the novelty is lost, you will not get a patent later. So if the invention is worth filing a patent, just wait and first file the patent and then go for publication. Okay, that is what novelty means. So that is the first condition. So to illustrate the example of novelty, you can take an example like, for example, I say, if you are inventing a product or a process comprising of three features, feature A, feature B, and feature C. So that product is having three new features. Okay. And the prior art document, D1. Prior art document means existing invention. Okay, existing invention, that is being referred as D1. It has got the feature of A, C, and D. So it also has three features, but I am having the feature of A, B, and C. Okay, the existing invention has got the feature of A, C, and D. So what happens is that for checking the novelty clause, we have to compare our invention with each of the existing invention. Okay, so I will compare my invention with that prior art document D1. So when I am comparing my invention with that prior art document D1, my invention is new. Why? I have introduced a feature B, which is not available in the prior art document D1. Okay, so in that case, we can say that that claimed product is new with respect to the document D1. because that feature B is not disclosed in that prior art document. Okay. So take the case of another document, that is prior art document D2. Okay. So it has got 4 features. It already has the feature of A, B, C, and D, whereas my invention has got only 3 features. So the all the features which I am covering is already there in that prior art document D2. So as compared to this prior art document D2, what happens? My invention is not new. Okay, this is how we will check the novelty of our invention with the existing invention. So if you are introducing any new feature in the existing invention, your invention uh, will pass the criteria of novelty. But that doesn't mean that you will get the patent, because there are some other criteria also. Okay, for getting that novelty clause or getting that novelty condition, then we have to introduce a new feature which is not available in the existing invention. That is what novelty means. This is the example of that same invention which has got feature A, B, and C. Like it's a chair which has got a seat and which has got legs as well as wheels. But the prior art document D1 has got seat as well as legs, but it doesn't have any wheel. So the wheel is my new feature in that my invention. So that product is new when compared to document D1. But in the document D2, it already has got seats, legs, and wheels. So that as compared to that product, the invention is not new. So that is what novelty means. Then the second criteria is inventive step. This is one of the difficult criteria to pass, because most of the inventions will be having novelty clause. If it is not published before, many inventions are having that novelty clause. But as far as inventive step is concerned, inventive step means there should be some technical advancement in your invention as compared to the existing knowledge. As compared to the existing invention, there should be some technical improvement, or it should have some economic significance which is not obvious to a person skilled in the art. That means a person who is having an average knowledge, it's not an expert. A person skilled in the art means a person who is having an average knowledge in that field. He should not be able to identify what inventiveness you have made in your invention. That is the technical advancement. Okay, that is we call it as inventive step. So it should either have a technical advancement or economic significance. For example, if you are having a technology which is already available, but that is very expensive, and if I am coming up with an alternate version of that technology, which can be sold at a lesser price without compromising the quality of that invention, then it will be considered, it can be considered as having an economic significance. So it should either have a technical advancement or economic significance, and that advancement should not be obvious to a person who is having an average knowledge in that field. That is what inventive step criteria means. And the third one is industrial application. Industrial application means it should be capable of being made or used in the industry. It should be able to be reproduced in the industry. So it should be useful. The invention should be useful. Then only it qualifies the criteria of industrial application. Okay. So the patentability criteria means novelty, inventive step, and industrial application. Then comes, we are having in the Indian Patent Act 1970, we are having 2 sections, that is section 3 and section 4, which says what are not patentable, non-patentable inventions. So even if these inventions has got novelty, inventive step, and industrial application, if it belongs to any of these inventions disclosed in the section 3 and section 4, it is not patentable in India, which includes frivolous inventions like crazy inventions, silly inventions, or inventions contrary to the well-established natural laws. For example, like if somebody is claiming a perpetual motion machine, anything which is against the laws, anything which is against the thermodynamics principles or any theories or principles, existing theories or principles, if any invention comes up claiming contrary to these theories, it is not patentable as per section 3A. Then mere discovery, as I said, discovery is not patentable. Discovery of new form of a non-substance, new use of a non-substance, such things are not patentable in India. Then inventions which are against the public order or morality. For example, if I am inventing a device for housebreaking. Uh, Even if it has got novelty, inventive step, and industrial application, you will not get a patent for that because it is against the public morality. So anything which is against the public morality, anything which is against the health of the human beings, that is not patentable. Then substance obtained by mere admixturing of components. If I am having a component or a compound A, compound B is already there. What I have done is I have simply mixed these two compounds and come up with a new compound which has got the same effect as that of these individual compounds. It is not considered. That is mere admixturing only. Then mere arrangement or rearrangement or duplication of known devices. For example, if I am having a umbrella with a fan, umbrella with a fan. Umbrella is already there, fan is already there. I have just arranged these two components into a single product. If it works independently of each other, then it is not considered as patentable. Okay, then again, method of agriculture or horticulture. That method or process of agriculture or horticulture is not patentable. But agricultural equipments and agricultural devices can be patented in India. Similarly, any process of treatment, any process of diagnosis is not patentable. That process, that method is not patentable, but there also surgical instruments and equipments can be patentable. For example, if a doctor invents a new method of performing a surgery, he cannot get a patent for that new method, that method. What happens if a patent is granted to that doctor? He can prevent other doctors from using that method. So that is not possible there. But if he comes up with a surgical device or an instrument, that is eligible for getting the patent protection. Then plants and animals involved or any part, including seeds, such things are not patentable. Then mathematical methods, business methods, or computer program per se. We cannot patent a source code as such because computer programs as such can be copyrighted. It cannot be patented. If you are having a business idea, if you are having a business concept, or if you are having a mathematical idea, mathematical equation, then you will not get a patent for that. You have to apply for copyright protection. Algorithms, such things are, these are all being considered as a literary work that is not patentable. Then copyrightable material like literary work, cinematographic films are not patentable. Then method of teaching or a new method of teaching or a new method of playing a game are not patentable. That is not patentable. Then presentation of information is not patentable. The topography of integrated circuits is also not patentable. And any invention which is related to the traditional knowledge related inventions are not patentable in India. Similarly, any inventions which is related to atomic energy is also not patentable. So that is what section 3 and 4 means. It defines a lot of inventions which are not patentable in India. So for getting the patent protection, our invention should satisfy the first three criteria of novelty, inventive step, and industrial application. And also, it should not be among these non-patentable subject matters. Then only you will get patent for your invention. And also for the inventions related to defense related inventions will not be granted patents. What they will do is that patent office will refer that invention to the DRDO, and secrecy directions will be maintained. It will not be published anywhere, and DRDO will examine the invention, and if it is found useful to the country, government will take over that invention, but patent will not be granted for these defense related inventions. Then, as far as patent is concerned, there is a big myth like for getting the patent, the invention should be complex or a breakthrough one. Only complex inventions will get patents, like that. There is a big myth like that. As far as patent is concerned, simplicity is no bar for getting the patent protection. As you know, basically, what's an invention? Inventions are basically solutions to the problems, right? Solutions to the problem. So if it is a small invention or if it is a big invention, no matter whether it is simple or complex, if it satisfies the patentability criteria, even simple inventions can be granted patents. And the best known example for this is safety pin. Safety pin was a patented invention. So the patent was granted by the United States Patent Office to an inventor named Walter Hunt in the year 1849. So if safety pin can get a patent, our inventions will also get patent, right? So that's what we said. Simplicity is no bar for getting the patent protection. Even small inventions can get the patent protection. These are all the inventions. These inventions were patented once. Our paper clip, which we are using, band-aid, rubber band, safety pin, then micro sprinkler, then this coconut dehusker, which we all use in our home. So this is a milking apparatus. All these inventions were patented inventions once because the validity of patent has been expired. That's why I said it was patented once. So these inventions are even these inventions are all small inventions, right? It's not complex, not that much complex inventions, but these inventions were once patented. Okay, suppose if you are having an invention, maybe a small invention or maybe a big invention, whatever maybe, you have got two options. One is you can publish it. You can publish it in the media, you can publish it in a journal, or you can take a video of that and upload in the YouTube. You can publish it in the social media, wherever you want, you can publish it. And the other option is you can patent it. You can file a patent also. So what's the disadvantage of the first option? If you publish your invention first, then it is difficult to get the patent protection because once published, novelty is lost. Then you will not get a patent for that. But the reverse process is easy because if you are having an invention, you can file a patent today and next day you can publish it wherever you want. So that you will get both patent as well as you will get the recognition out of this publication. So we always advise the inventors to first file patent and then go for publishing. Okay, so if you decided to file to go for patent filing, so first thing you have to check is whether your invention is in the prior art. So prior art is nothing but any information which is already available in the public domain is known as a prior art. Any information which is already available in the public domain in the form of books, journals, magazines, websites, any document. Okay, so that is prior art, and your invention should not be a part of this prior art because your invention should be new, should not be disclosed anywhere. So that is what we will be doing prior art. We have to check whether your invention belongs to the prior art. For that, we have to do a process called patent search because you have the idea, you are working out on that idea, but you are not sure whether somebody has already done it in any part of the world, right? You may not be able to aware, you may not be able to know whether that has already been done. So to check whether the invention is new and whether it is patentable, you have to do the patent search because the novelty clause, which I mentioned in the previous slide, means it should check for the global novelty. That is, it should be globally new. It's not like that it should not be published in India only. No, it should not be published anywhere in the world. So that's what I said. For before filing the patent application, we have to check whether your invention is new. So for that, we have to do the patent search. We have to do the patent search globally. You have to check whether the invention is already patented in India, America, Europe, China, Japan, all the countries. If it is already been granted patent, if it is been patented anywhere in any of these countries, you will not get a patent for the same invention. So for that only we are doing the patent search. And there are various reasons to do the patent search. First thing is we have to check whether it is patentable or not. That is the first case. And for filing the patent, it involves some fees. We have to pay some fees to the patent office. So before making such payment, we should make sure that whether it is worth filing a patent. So that is another reason. And based on the search result only, you have to take the decision whether to proceed further or not. And it also gives you information about the inventors and the owners of the existing patents, and you can even identify the competitors for the same technology. So there are a lot of advantages in doing the patent search. So what happens is that when you are doing the patent search, you will come across some patented documents on the same field of your invention. Okay, that is what you will get it. Okay, if you find out that the invention which you proposed is already there, then there is no point in moving forward. Then in that case, what you have to do is you have to study the similar patent document, identify the drawbacks in that patent, come up with a solution to that problem, and file a patent for that particular invention. So it is also a reference material to improvise our invention. So because while doing the patent search, you will come across a lot of patent documents, US patent documents, European patent documents in the same field. You can make a study on that and you can improvise on that. Okay, so that is another advantage of doing the patent search. And these are all the some of the freely available. There are two types of patent databases: freely available databases as well as paid databases. Paid databases are very expensive. These are all the freely available databases. Most of them are the websites of the different patent offices. First one is the website of the Indian Patent Office. You can do a patent search in the Indian Patent Office, and you can make sure that that particular invention is not patented in India. So that is the first one, website of the Indian Patent Office. Second one is the website of the European Patent Office. There you will get the details of European patents. And we have the website of US Patent Office, Singapore Patent Office. Then we have WIPO, and we can even do the patent search in Google. That is Google Patents. So the reason why I have highlighted this Indian Patent Office and the Google Patents is that uh, we can do the patent search in Google, and while doing the patent search in Google, Google will fetch you the patent documents of almost all the countries, like US patents, European patents, Chinese, Japanese, Korean patents, and all will be covered in this Google patents. But Indian patents are not available in the Google patent database. So you have to do just a patent search in the IP India website and then in Google patents. So by doing this search in these two domains, you will get the documents, similar documents, patent documents. Okay, this is the website of the US Patent Office. There is a provision for a basic search. Okay, so here we can type the keywords. Just type the keywords related to your invention. I put the keyword like mosquito and trap. Okay, then it will list out the documents with that keywords. Okay, a lot of patent documents are available there. We can just click on this PDF link, then it will go for the entire PDF document of that patent. It's a US patent. Okay, so what you have to do is while you will get this document. Okay, this document which you can download it. You can download it. This covers the entire patent document. So what you have to do is when you are getting such a document, first you read the abstract. So by reading the abstract itself, you will be able to identify whether that invention is related to US. Okay. And if it is similar to that, then go for the drawing session, drawings. Then if it is again similar, then what you can do is you can just read the claims and identify the similarity with your invention. So that is the process of doing the patent search. This is the European patent website, patent search website. So there also I put the keyword like mosquito trapping device, and it will list out the documents, and you can click on that link. It will direct you to that PDF document. You can download it and you can read it, and you can make sure that your invention is not related to this. This is the Indian Patent Office website, Indian Patent Office website, IP India. Here also you can type the keyword here. You can type the keyword and go for the patent search. It will list out the Indian patent documents. Here you can see the documents. You can click on this link. It will direct you to the patent document. So this is the way of doing the patent search. You yourself can do it. If you have any innovative idea, no need to disclose to any other person. You can just simply do a patent search on your own and identify the novelty of your invention. So these are the basic patent search websites, and this is the Google patent website. Similar to the web search, we can do the patent search in Google. Okay, so after doing the patent search, if you are confident that your invention is different from the existing invention, then you can go for patent filing. So in India, we have got 4 patent offices with the head office at Kolkata and having branches in Delhi, Mumbai, and Chennai. So all the patent applications from Kerala has to be filed in the Chennai patent office. So who can file a patent? So as far as patent is concerned, education is not a mandatory for filing a patent. Age is not a matter. Only thing is that you should be the inventor of that invention. So any person who is the true and first inventor of the invention can apply for a patent, or assignee of the inventor can also file a patent. In the case of a deceased inventor, legal representatives can also apply for a patent. And there are 2 modes in which we can file the patents. And first one is the physical mode, like we can download the application forms from the patent office website, download it, just type the details, then send it over post. That is the physical mode. And we are also having the option of e-filing. So e-filing is very easy. Only thing is that just a digital signature is required for doing the e-filing. Advantage is that 10% fee reduction is also there. And once you submit the application online, immediately you will get the application number. Whereas in the case of physical filing, you have to send it over post, right? Then it has to reach there, it has to be documented, then they have to send the acknowledgement back to us. It will take some time, but in the case of e-filing, immediately you will get the application number. And this is very important. As far as patent is concerned, we have got 2 types of specifications. One is provisional specification and another one is complete specification. Suppose you are having an idea, you are doing that work, but your work is not completed. Okay. But you have a fear that somebody else might copy your invention. Okay. Then in that context, you can apply for this provisional specification. No need to complete your invention for filing a provisional specification. You can give a brief write-up of your invention. What is your invention? What are you going to do with that invention? Like that, you write it in the application form and file it in the patent office. The advantage is that if you are filing a provisional specification today, you will get an application number. You will get 1 year time, 12 months time is there. Within that time, you should complete your invention and you have to file the complete specification. So advantage is that if you are filing a provisional specification today, from today onwards, you will get a priority for your invention. The date of patent will be today. Okay. So you will get 12 months time to complete your invention and file the complete specification. And within that period, you can disclose to any person because you have already filed the patent application in the patent office and patent office has given you the application number. So that is what the advantage of provisional specification. Then provisional specification will be taken only if it will be processed further, only if the complete specification is filed within that time frame, that 12 months. Within 12 months, you should file the complete specification. Otherwise, what happens is that your provisional specification will get abandoned. Then again, you can apply for the complete specification. No problem is that. There is no problem in that. But the issue is that you will lose the date, that priority date, you will lose it. So that is what provisional specification and complete specification means. And if your invention is already completed, you can directly file a complete specification. This is the patent procedure, patent grant procedure. It's a brief procedure. Like first you have to file the patent application through online or offline mode. Then you will get a patent application number. Normally, what patent office will do is that they will keep your invention secret for a period of 18 months, 1.5 years. Okay. And if you are not willing to wait for this long period, you can apply for a early publication. You can file a request for a early publication. In that case, your application will be published in 1 month. Normally, it will get published after 18 months. But if you apply for a early publication, it will be published in 1 month. Then second step is you have to file a request for examination. So what happens is that patent office will publish your invention in their journal. That journal means in their website. Every Friday they will be publishing the application. So the reason why they are publishing is that if somebody want to oppose you, That is what call it. There is something called pre-grant opposition. Before the grant of patent, if somebody wants to oppose your invention, then they have the provision to file this pre-grant opposition. Because till the application gets published, only you and patent office know that you have filed a patent. It's not, it's a secret only. Okay. Once it get published, then only a third party came to know that a particular invention has been filed. Okay, so if they are having any opposition, they can file a pre-grant opposition to the patent office. Patent office will send that notice to the inventor. Inventor has to give a reply to that, and if you are able to uh, clarify on that pre-grant opposition, the application will be taken further. So next step is you have to file a request for examination. You have to request the patent office to examine your application. Two types of examinations are there. One is normal examination. Another one is expedient examination. Expedient examination, actually that provision has been introduced basically for the startups, because normally it will take 3.5 years time to get it examined in the normal course. But as far as a startup is concerned, they cannot wait this much time. Okay. So for them, they have introduced the provision of expedient examination. So the advantage is that if you are applying for this expedient examination, within 3 months' time, you will get the examination report, and the entire patent process will be completed in 1 year time. Normally, it will take 3 to 4 years time, but that can be reduced. The time frame can be reduced to 1 year in the case of expedient examination. But that option is not applicable to all. That is applicable to the startups, MSMEs, and in the case of individual inventors, if there is at least one woman applicant, you can apply for this expedient examination. And also for these government institutions and government departments or government companies, they can also apply for this expedient examination. So startups, MSMEs, women applicants, and government institutions only can avail this expedient examination. Others has to go for the normal examination. So what happens is that once you file the request for examination, there is a time frame for filing this request for examination. The time frame is 31 months time from the date of filing the patent application. From the date of filing the patent application, within 31 months time, you should give the request for examination. If you are not filing the request for examination, your application will get abandoned. Okay. So what happens is that once you file the request for examination, when your turn comes, your application will be sent to a patent examiner who will be an expert in your field of invention. He will examine the patentability criteria like novelty, inventive step, industrial application, section 3, section 4, like that. He will examine your application in detail and will issue a first examination report, that is FER, first examination report. And this report will be having all the queries raised by this patent examiner while examining your invention. He will make a query like that: your invention is not novel, it is not inventive, it is not patentable as per section 3 A, B, C, or whatever may be, like that. It will be a big report like that. It will be a detailed report, examination report. So what, as an inventor, what you have to do is you have to study this and give a reply to this examination report. You have to give a reply to this examination report within 6 months time. That is a time frame for giving the request reply to request for first examination report. And if you are able to convince the patent examiner, then patent will be granted. If he is not yet convinced, what happens is that they will invite you for a hearing. So nowadays, hearing is being conducted through video conferencing only. Patent examiner will be there. Inventor can also be there. You can have a face-to-face interaction and get it cleared. So if it is cleared, the patent will either be granted or it will be refused. And what happens is that after the publication, after the grant of patent, also they will publish it in the journal. So and so has been granted a patent, like that. They will publish it because there is something called post-grant opposition. Once your patent gets granted and published in the journal, within 1 year, any interested person, not all person can apply for this post-grant opposition. Interested person can apply for, any person who is affected by this invention can apply for this post-grant opposition, and final decision will be taken. So if the patent is been revoked or patent is been rejected by the patent office, then you can approach the court. Because earlier there was an IPAB, Intellectual Property Appellate Board was there, but now it has been demolished. And after that, what happens is that you have to go to the High Court against the decision of the patent office. So this is the patent certificate. After all this procedure, you will get the certificate which has got a patent number, then application number which is already been allotted at the time of filing the application, and the date of filing will be there, and patentee. Patentee means owner of the patent. So here comes the role of applicant and inventors. In the patent application, there are two fields, like applicant is there and inventor is also there. So those who want to be the owner of that invention should be the applicant. For example, if a patent comes from the St. Thomas College and St. Thomas College is the owner, wish to be the owner of that patent, the applicant will be the St. Thomas College, and those who worked in that invention will be the inventors. So that's the field in which the name has to be given. And if you are filing a request, additional request, the name of the inventors will also be reflected in this patent certificate. So all the economic rights, all the monetary rights related to the patent will go to the applicant, to the patentee, and not to the inventors. Okay. So this is the fee schedule, e-filing fee schedule with regard to the filing of patent. For filing a patent application, 1,600 rupees. If the application is in the name of an individual or a startup or an MSME or an educational institution. If a patent is filed in the name of a college also, same fee is there. Okay. Earlier it was not like that. It was in this category only. Educational institutions were there, but now it has come to the category of individuals. And for request for examination, 2,500, normal examination 4,000 rupees, and expedient examination 8,000 rupees. And this is the renewal fee. The first 2 years, no renewal is required. From third year up to the 20th year, you have to pay the renewal fees, 800 rupees per year. And you can see that as the time goes, it goes up. The renewal fee goes up. So that's what I said. That's the maximum term is 20 years. So in between, if you fail to file the renewal fee, what happens? Patent will be abandoned at that stage and it will become a public property. So the maximum term of protection is 20 years from the date of filing of patent application. If you are filing a patent today, the term of patent starts from today itself, not from the date of grant of patent. From the date of filing of patent application, the term of patent starts. And what are the duties of the patent? As far as a patent is concerned, the duty starts once the patent gets granted. He has to pay the renewal fee promptly. Every year he has to pay the renewal fee, and he has to commercialize that invention. The purpose of giving the patent is that you have to commercialize your invention and make it available to the public. If you are not able to do yourself, you identify an industry and transfer the knowledge to that industry, let them do it and make it available to the public. So commercialization either by yourself or through licensing, it is mandatory, and you have to give a periodic report to the patent office regarding the commercialization of this invention. As per the present rule, every 3 years, you have to give the report to the patent office. So these are the duties of the patentee. Then there is another myth regarding to patent is that there is something called a world patent or an international patent, because many inventors are approaching us saying that I have got a brilliant idea. I want to get a world patent so that nobody in the world should be able to copy my invention. So that is not possible. As I said earlier, patents are basically territorial in nature. So each country will be granting patent in that country. Okay. So because the Patent Act also in every country differs. But there is a shortcut to file an international patent application. It's not a patent, it's an international patent application. That is PCT, Patent Cooperation Treaty. It is an international treaty which was being introduced in 1978. India is also a member of that treaty. Nearly 152 countries are there, members in that PCT. So the advantage is that if you want to get an international patent application, you want to file it. First, you file a normal patent application in the Chennai Patent Office, and after 6 weeks and within 12 months, you can file a PCT application again in the Chennai Patent Office. Okay. So when you're filing a PCT application in the Chennai Patent Office, and if you are designating all this, you can select whichever countries you want to get the priority. Okay. If you are selecting all countries, the advantage is that your invention will get priority for 31 months time in all these 152 member countries, because we will not be in a position to file patent in all these 152 countries, right? We may be able to do it in a couple of countries only. So, but you will get a priority for your invention for 31 months time. Within that period, you have to file separately in whichever country you want. Okay. So this is the route which is been adopted by all the multinational companies. They will be filing a patent in one country first, and followed by the PCT application. Then they will do a market study and file in those countries where they have got demand. So that is the provision. That is what PCT means. PCT never gives you the international patent. Patents are basically territorial in nature. If you are having a patent, and if you are getting a patent from the Indian Patent Office, there is no compulsion that you should get the patent from US also. Because no, it's depend. The decision depends upon each country. Okay, so PCT will give you an international filing shortcut route. Then, as far as patent is concerned, don't lose the chance for getting the patent by publishing it. If you publish it, then you will not get a patent. If you publish the technical details, that's more important. If you publish the technical details, then it will be difficult to get a patent later. And don't use it in the public also. Okay, and don't wait for the full development. We have the provision of provisional specification. Once it gets into a particular shape, just file a provisional specification first and then go for complete specification, and don't wait for the full development, because as far as every country is concerned, those who file first will get the patent. Okay. So first to file will get the priority. So file as fast as you can. So that is the principle for filing the patent also. So that's all about the patents I have covered, because being the faculty members and engineers, more trust is being given to patents. Okay, now we have got the other 6 forms of IPR also. I will quickly go through the other IP forms also. So as I said, patent protects inventions and innovations. So we have got another IP which is known as copyright. So copyright is nothing but it protects creative works. Any creative works are being protected. Literary, dramatic, artistic, scientific works are being protected under copyright. Cinematographic films, sound recordings. Then, as I said earlier, computer program per se, source code as such, that can be copyrighted. So any literary work, if you write a textbook, if you write a novel, if you draw a picture, if you make a drawing, any creative work can be protected under copyrights, music and all. So as far as the copyright system is concerned, we are having the Copyright Act 1957, which is being supported by the Copyright Rules 1958. So recently, it has last time it has been amended in the year 2013 only. So in India, we have got only one office for copyright, that is at New Delhi. And here also, we can, if you wish to apply for a copyright protection, you can do it through online. E-filing provision is already there. Okay, so what copyright protects? As I said, copyright is the exclusive right to the owner of a literary, artistic, or dramatic or musical work for a limited period of time. Okay, so copyright basically protects expression of ideas. If you are having an idea, you have to express that idea into a tangible medium. You have to write it in a piece of paper, or you have to record it into a CD. Okay, so you have to express your idea or thought into a tangible medium, then that work can be protected under copyright. Idea as such cannot be copyrighted. Similarly, in the case of patent also, there is another myth, like there is something called idea patent also. There is nothing like an idea patent also. If you are having an idea and if you want to get a patent for that idea, you have to convert that idea into a product or a process. then only you will get a patent for that. Idea as such, we cannot patent it. Similarly, in copyright also, we cannot protect the idea as such. We have to express it into a tangible medium. And copyright will give you a bundle of rights, like right for reproduction, right for adaptation and translation, right for distribution, right of public performance, and right for broadcasting. If you are writing a book in Malayalam and got a copyright for that, you only have the right to translate it into any other language, or with your permission only any person can do that. So that right is also, it's a bundle of rights. Copyright will give you a bundle of rights to the creators. These are all the subject matters of copyright, like books, paintings, drawings, musical work, photographs. Creative photographs can be copyrighted. Regarding the authorship of copyright, in the case of a literary work, if I am writing a book, I will be the author of that copyright normally. Okay, I will be the author. In the case of a music, it's the composer. Those who compose that music will be the author of that copyright. In the case of an artistic work, it will be the artist. And in the case of a photograph, it will be the photographer. And for cinematographic film, it will be the producer, those who spend the money. So he will be the owner of that copyright. Okay, that is the authorship of copyright. Then there is something called fair use in the Copyright Act. Fair use means uh, we can use a small portion of the copyrighted work for educational purposes or research purposes. That comes under fair use. For example, if you are having a textbook, copyrighted textbook, you can take a photocopy of a couple of chapters from that textbook for study purpose or for teaching purpose or for research purpose. That comes under fair use. But taking the entire photocopy of that textbook comes copyright infringement. Okay, fair use allows a small portion of the work from a copyrighted work can be taken for educational purpose. That is what fair use means. And as far as copyright is concerned, a lot of myths are also there, like everything is copyrightable, like that, including speech. As I said earlier, only if you are in the case of a speech, if it is recorded, then it can be copyrighted. Otherwise, it cannot be copyrighted because it should be recorded into a tangible medium. Then, as I said, ideas are copyrightable. You have to express that idea into a tangible medium, then only you can get the copyright. Then, as far as copyright is concerned, the biggest advantage is that registration is not mandatory to get the copyright protection as far as the act is concerned. Okay, if you are writing a book, as per the act, once you complete the writing, that copyright belongs to you. No need to have a formal registration for that. But we always advise to have a registration because registration process is very simple and less expensive, and you will get the copyright registration within 6 months also. But later, in the case of some infringement or some court proceedings is there, if you are having a certificate in your hand, it will be easier to defend. So as per the act, copyright registration is not mandatory. Once the work gets over, copyright is there. For that, what you have to do is you have to prove to the court that you have created that work on such and such date. So that is the rule. And another thing is that myth is that copyright does not apply to internet materials. It's not like that. Anything which is available in the internet, all the contents are being copyrighted. So normally, if you are taking something from the internet, you should acknowledge the source. At least you should acknowledge the source. Otherwise, it constitutes a copyright infringement. Then another thing is that I use the copyrighted work without the knowledge that it is copyrighted. We cannot simply escape by saying this. It's not like that. Ignorance is not an excuse. So you should know that whether it is copyrighted or not. And fair use allow me to use any copyrighted work. As I said earlier, fair use, there is a limitation is there. Once it crossed, what happens? It will become an infringement. Then another important thing is that copyrights are international rights. Okay. So for getting the patent, you have to apply in each and every country. But for getting the copyright protection internationally, you need to apply in the New Delhi office only. The copyright protection is international. Then copyright violation is not a serious offense. That is another myth. It's not like that. As far as copyright is concerned, there are criminal remedies also there. Minimum 6 months to 2 years imprisonment, and a minimum 50,000 rupees to 3 lakhs fine is also there as far as the copyright violation is concerned. It's a serious offense, copyright infringement. So once a copyright is created, it's forever. It's not like that. It is for a limited period of time. And once a copyright is sold, the other loses all right. It is also not there. If I am the owner, I am the author of a book, and at a later stage, if I am giving the authorship or the copyright ownership to my publisher, then also the moral right resides in me, because I only wrote that book. So all the economic rights will go, but that moral right will always be vested with the author. So protection is basically for 60 years. Generally, in the case of a literary work, it will be a lifetime of the author plus 60 years. Entire lifetime plus 60 years, he can enjoy the protection. Okay. And 60 years from the date of registration. In the case of cinematographic film and sound recording, 60 years. And for broadcasting right, it will be 25 years. And as far as fee is concerned, only 500 rupees is there for registering a literary, dramatic, musical, or artistic work. And for cinematographic film, 5,000 rupees, and sound recording, 2,000 rupees. Another interesting thing is that no need to renew it. If you pay 500 rupees for a literary work, no need for renewal. You will get the protection for your entire lifetime plus 60 years. No renewal is also there. That's why we said just go for registration, formal registration. So that's about copyright. Then we have got trademark. You know, you are well aware of, you may be well aware of this trademark. Trademark is nothing but these companies, they will be using some distinguishable signs or symbols to identify the source of their products from those of its competitors. These are all trademarks, distinguishable signs and symbols. They want to distinguish their products from its competitors. For that, they are using some signs and symbols. That is what trademark means. And a trademark system, we have got the Trade and Merchandise Mark Act 1958, which was amended a couple of times, and we are having the rules 1959. And what's the function of trademark? Basically, to identify the source from where this product is coming. Just by seeing this logo only, you will be able to identify from where this product comes. And it also guarantees its quality. It's not necessary that it's not a legal guarantee or nothing like that. It makes us believe that a product of a particular brand has got a particular quality. That's all. And it also advertises the goods and services. Different types of trademarks are there, like the word mark, like for Toyota, abbreviations, numbers, letters, slogans, sound, even smell mark is also there. You know about many slogans like do it yourself, express yourself, like that, and sound, the ringtone or the tone of Nokia phone, and even the smell mark also there. Logos can be registered as trademark. These are all the this is called service mark. Service mark is nothing but if we are using certain marks to distinguish the service which we are offering. That, for example, if you want to register the logo of your institution, you can register as a service mark because you are offering service. Indian Railways, their KSRTC, banking system, insurance companies, they will be using that. Then some certifications mark like ISI mark, Hallmark, BIS mark. Certain products which has got a particular quality standards are being preferred as a certification mark. Then we are having collective mark also to distinguish the professions. This mark, this belongs to doctors, right? While seeing this mark, we can identify that he's a doctor. Okay, so that is what collective mark means. And chartered accountants, engineers, they can all use the marks. These are some of the traditional trademarks which you are very familiar of, like smell mark, packaging, colors. These are all comes under trademark. The India's first sound mark was awarded to Yahoo for its sound jingle model. Then here we can see some deceptively similar marks. So when you're seeing that, this is what the mark should not be deceptive. It should not be confusing to the customers. When we are seeing these two products, we'll be in a confusion, right? Which one is original and which one is fake? It should not be like that. Such marks cannot be granted trademarks. Like Adidas, you can see that like that. Okay, so as far as the trademark is concerned, fee is 4,500 rupees, and the protection will be initially for a period of 10 years, and it can be renewed indefinitely. Indefinitely means every 10 years by paying the renewal fee, you can get it renewed. But the protection will be up to indefinitely, you can renew it. That is the advantage of trademark. Then comes industrial design. Industrial design means the aesthetics of the product, the external appearance of the product can be protected under industrial design. It has nothing to do with the functional aspect. The shape of this bottle, if the shape of this bottle is unique from the existing bottles, you can apply for a industrial design protection. Only the shape or pattern or orientation can be registered as industrial design. The condition is that it should be new or original, and it should relate to the features of shape, configuration, pattern, or ornamentation. Okay. The external appearance of a product can be protected under industrial design. If there is anything technically which is to be protected, you should do it through patents. Aesthetics can be protected under industrial designs. There are some non-registrable designs also, like calendars, certificates, leaflets, postcard, stamp, labels. Such things are not be not cannot be registered as industrial design. We are having the Design Act 2000 supported by the Design Rule 2001. You can see in the case of all the ornaments are being industrially registered, industrial design registered. And the shape of these containers are also vehicles, our gadgets are all. Because for every product, because design add value to that product, we will be finally deciding whether to buy it or not based on the design of that product only. So every designs are being registered. Registration fee is only 1,000 rupees for an individual, and the protection will be initially for a period of 10 years and can be renewed for 5 more years. So maximum 15 years you can enjoy the protection of industrial design. So there is another myth, there is something called a design patent. Okay, as far as India is concerned, we don't have any sort of design patent. We have only one patent, and if you want to protect the design, you have to apply for this industrial design. But in some other countries, there are design patents are also there. But in India, we are having only industrial design registration. Then we are having geographical indication. Geographical indication means the products which is coming from a particular geographical area, if it has got some quality, reputation, and unique characteristics, which are attributable to that place of origin, such products are having the GI tag, geographical indication tag. It will be exclusively for products. The function is to identify the origin from where this product is coming. Okay, these are all the examples. We're having the GA Act 1999, Darjeeling tea, Kanjipuram sari, Alfonso mango. Just by hearing this name only, we will be able to identify from where this product is coming. Just to identify the origin of the product, we are having this GA tag. As far as Kerala is concerned, we are having nearly 40 GA registered products, which includes our Navara rice, Palakkadan Matta, Aramula Kannadi, Nilambur Teak, Alapi Kair, Pokali rice, and lot of products are being there from Kerala, which has got the GA tag. The advantage is that only those producers who are in that particular area can sell these GA registered products. That is the protection it is being offered by this GA. Registration fee is 5,000 rupees, and similar to that of the trademark, it will be initially for a period of 10 years and which can be renewed indefinitely by paying the renewal fee every 10 years. Then there is another form of IP, that is semiconductor IC layout design. This is not that much popular. The topography of semiconductor ICs, the layout of components in this integrated circuits, if it is original and distinctive and distinguishable, then that layout can be registered as the IC Layout Design Act. Term is 10 years from the date of filing of the patent application, but not much application has been filed in our country regarding this IC layout design. Then we are having the plant breeders, right, for protecting the new varieties of plants and farmers, right. We are having a protection of plant varieties and farmers, right, at 2001. If a farmer is coming up with a new variety of plant, then he can apply for protection under this act, Plant Variety Protection Act. And finally comes trade secret. So initially, I said about patents, the requirement of patents. For getting the patent protection, disclosure is mandatory. And if I'm not willing to disclose my invention to the government, the other option is that I can keep it as a trade secret. Okay, the Coca-Cola is the best known example for a trade secret. What they have done is that they didn't patented the recipe of Coca-Cola. Instead, what they have done is that they have kept it as a secret. So, what would have happened if they filed a patent? Then, after 20 years, their protection ends. And now we also can make could make Coca-Cola in our home, right? But what they have done is they have kept it as a secret. Okay. So there are advantages and disadvantages for a trade secret. When trade secret are preferred means when the invention is not patentable, we can just go for this trade secret. And patent protection is limited to 20 years, but secret can be kept. As long as we can keep it as a secret, we can enjoy the protection. That is the advantage. Okay. As long as we can keep it as a secret, we can enjoy the protection of this trade secret. But once the secret gets lost, gets leaked, then protection will end. So there are advantages as well as disadvantages. And not only this Coca-Cola, this KFC and Cadbury, they have all uh, made their recipe as trade secrets. So this is another form of intellectual property rights. So in brief, these are the main forms of IPR which we have covered. Patent protects inventions, and we know the criteria of patentability, novelty, inventive step, and industrial application. And trademark protects logos and symbols, and the maximum term is indefinite. You can renew it indefinitely. Industrial design will protect the shape, orientation, and pattern. Condition is that it should be new and original. Maximum term is 15 years. Then we have got copyright, which protects literary, dramatic, artistic work. And normal period is 60 years. And geographical indication protects the goods originating from a specific region. And the maximum protection is indefinite. So these are the main 5 forms of intellectual property rights. And we are having a World Intellectual Property Organization. It is an agency under the United Nations which governs the IPR related matters between different nations. And it is situated at Geneva, Switzerland. And every April 26th is being celebrated as the World Intellectual Property Day. All the IPR related issues between the nations are being controlled by this World Intellectual Property Organization. So that's all about an overview of intellectual property rights. And before I conclude, I will just quickly go through the organization which I represent. I am representing the Intellectual Property Rights Information Center Kerala. Formerly, it was the Patent Information Center Kerala, which has been functioning since 2003. And we have been functioning as the nodal agency of the Kerala state for all the IPR related matters and services. We are providing services with regard to all forms of intellectual property rights like patents, copyrights, trademarks, designs, TA, and all. And we are acting as the advisory center for the government of Kerala on all IPR related matters. And we are providing many services to the inventors with regard to the filing of patents and all. We are providing the technical and legal support for filing IPs. We have been conducting the patent search, which I mentioned in my presentation, like patent search. If you are not confident in doing the patent search yourself, you can avail the service of IPRIC. We will be conducting the patent search free of cost, and we will inform you whether the invention is patentable or not. And that too free of cost only. And we even facilitate the filing of patents through our empaneled IP firms. And we are also having a scheme of providing technical, legal, and financial support to the financially backward grassroots innovators for filing their patents also as per the IP policy of KCSG. We have already empaneled IP firms for providing services to the inventors with regard to the filing of patents, not only for patents but for copyrights, trademarks, and all other IPs. And concessional fees have also has been fixed for these IP firms for providing the services. So that service also you can make use of it. And we are also providing the technical and financial support for IPR awareness programs also. It will be notified in our website. We provide technical and legal financial support to the institutions for conducting the IPR awareness program also. And these are the firms, empaneled IP firms of KCSG. Through these firms, we are facilitating the filing of IPs. Then we have conducted nearly 650 IPR awareness programs throughout the state right from 2003, and nearly 70,000 people were sensitized. And we have already processed 1,261 patent search applications, and we have generated the search report also, out of which we facilitated the filing of 142 patents and other 180 other IPs like copyrights, trademarks, and 46 patents were also granted. And we established IPR cells in 27 universities and institutions to provide IPR related services to the academic community. So if you want to avail any of the services of IPR Information Center Kerala, you can either call us or send an email to us. We will provide all the services with regard to the filing of patents. If you want to get the patent search done in IPRIC, we have a patent facilitation form which is available in our website. You can download it, fill the details of your invention and send to us. We will do the patent search and we will issue the patent search reports in 2 weeks at time. So not only patents, for other IP also we will be providing all the services to you. So that's all about an overview of intellectual property rights. So if you have any queries, you can ask. So thank you very much for your patient hearing. Thank you.
Hello,
Sir.
hello.
Sir.
Sabik, excellent presentation. I
Sir.
think one of the best presentations I have ever heard from your mouth.
Thank you, sir.
Even though I was traveling, there was some connectivity issue in between, but still, almost all I have heard, and it was very
Yes, sir.
refreshing also for me.
Yes, sir.
We used to do it together, and nowadays, I am completely pressed with a lot of administrative and other academic
Yes, sir.
activities.
Yes, sir.
No chance to deliver a speech, on IPR and all. So it was something like a refreshing thing for me. Thank you very much for that.
Yes, sir. Thank you, sir.
And
Thank you, sir.
yeah, I think as I have promised the faculty and audience, it was he made it so simple and comprehensive, and that is the specialty of my Safik. And probably I think there may be a couple of questions also. I'm sure. I hope you won't mind answering a few questions also.
No, sir. No, sir. I'm happy only.
Yeah, Dr. Vipin, Abida, please.
Yes. Yes, sir.
So it's a
Actually,
very so it's
yes.
a very informative session, a very simple session, and it's a very nice session, sir. Thank you, sir.
Thank
Uh,
Okay. Thank you, sir. Thank you.
it gives a
you.
very good introduction or a great awareness course on IPR, at least for the beginners.
Okay.
Sir, we have a couple of questions over there, and we can see Dr. Smita ma'am has raised her hand as well. Yes, ma'am, please.
Yes. Yes.
And I think questions are there in the chat box. So, how much will be the cost for taking trademark for the
Oh.
product
Okay,
brand?
okay. So for taking the trademark, the registration fee is 4,500 rupees per class, because there we are having nearly 45 classes for a trademark. So per class, if your product belongs to a single class, you have to pay only 4,500 rupees. That will be the official fee to be paid at the trademark office. And if you are filing through a trademark attorney, some more fee, professional fee also has to be paid. I think our professional fee is, I think 1,500 or so. So that's the only fee to be paid till the grant of trademark. After 10 years, you have to pay the renewal fee. That will be something like 9,000 rupees.
Thank you, sir. Any other queries? Okay.
There
Uh,
is a query like whether Tamil Nadu institution can avail the awareness programs. No, madam. Actually, only the institutions from Kerala can apply for this IPR awareness support.
any other queries? Okay. If so, we'll
So,
wind up. Yeah, yeah. Carry on, carry on. Yes, ma'am.
so
Yes.
there are some simplified textbook in our colleges, but
Okay.
that was taken from the foreign textbook. Actually, it is the Indian version of foreign textbook. They have taken some
Okay.
of the contents from the book. So is that a fair copyright? Actually, 75%, 75 to 80% of the contents are from the foreign textbook, but in a simplified way. So is that a fair copyright or
No, no, 75% is a big, big range. Actually, I think I think some 20 to 25 percentage only comes under this fair rule. Yeah, it's better you take the permission or written permission from the copyright owner. That's safe.
yeah?
Yeah.
Not sorry. See, I'm not writing, but I have seen some textbook. So
Okay, okay. If they are able to know about this, it will be a trouble.
okay, so thank you.
Yeah.
So there is one more question. What about service charge for patent filing? Yeah, Sabit sir.
Service charge for patent filing. Actually, we have fixed like professional charges on various categories because there are a lot of items which will come as part of this patent filing procedure. One is the patent search fee. If you are filing through KCSG, we will be doing the patent search, so that component will not be there. Main charge will be the drafting charge. So drafting charge, our fee is 18,000 rupees for the drafting of patent specifications. And some more fees will be there because once you get the first examination report, you have to give a reply to that report. So that will also be done by this patent attorney. So in that case, there will be some more fee. And if you want to get the full fee structure of KCST, if you can send an email to us, we will share that fee schedule also because it has got a lot of components there.
Thank you, sir. Any
Sir,
other
one more
query?
quick question,
Yes,
sir.
carry on, sir.
Yeah, yes, yes. Sabi,
Sir,
Sabi.
sir, sir,
Yes.
regarding your initial slides, that is the eligible criteria for applying patent. That means if if I have a technology which have features A, B, C, like that. If another technology is having A, B, D, and if another technology is having the B, C, D. So that means I am using B of the second one and A, C of the first one. So is that eligible for patent or
No, that's what I said. As far as novelty is concerned, it will be new. That
actually?
aspect will be okay. But whereas the inventive step criteria, regarding the inventive step criteria, there comes how much inventive is your invention as compared to the existing invention. So that will based on that only the decision will be taken. How much different, how much unique is your invention from the existing invention? Okay, so that's what I said. Novelty condition can be passed, but regarding the inventive step, we have to look in detail how much that is different.
Yes. Any other query? have a question from Anjan Nair, Dr. Anjan Nair. For music, usually who is the real owner of copyright? Is it
Yeah,
yeah,
actually, it's the composer. It's the composer for the sound recording and all. Because actually there are a lot of rights because it's been called it as a copyright and related rights. So everybody is having the right, but the major right will go to this composer. So the singers and other artists has the right of performers right. So they have the right to perform, but the basic copyright will go for this composer in the case of music.
yes. Any other queries? Okay, it seems no other queries. So we are about to end the
Okay.
Yeah,
session.
I have a doubt, Mr. Sabi.
Yes,
Kindly.
sir.
I have a doubt.
Sir.
In fact, in our college, we are doing, undergoing some workshop on drone making. Okay, drone making
Okay, sir.
workshop. Okay.
Okay, sir.
Suppose somebody comes up with an idea of a new application for a drone. Probably drone technology is known. Application may be something different. Maybe for finding out the leak in on the railway track or something like that, crack or leak or something, or even gas cylinders or some gas big containers are going. Maybe a drone can be used to check its leakage and other things. So like that, some suppose the application is innovative. Okay,
Yes,
so
sir.
how
Yes, sir.
can patent things can be applied there? Any possibility?
That we can look for it, sir. Actually, because that technology is already there. But if you are just going for a new application, and if it is innovative, if it is never tried before, then there is scope for getting the patent protection. We can look for it. No issue.
I think Dr. Vipin can take care of this.
Yeah, sure, sure, sir.
Yes.
We can help you, sir. We can help you in identifying the patentability scope also. That we will be able to
Thank
identify.
you, thank you.
Yes, sir. Yes, sir.
In the last 3 months, actually, we sent three ideas for patent
Yes,
search
yes.
from St. Thomas, from our college.
Yeah, yeah, yes, yes, yes. Two of them were forwarded to the attorneys also.
Yes, yes,
It's
yes.
in the process of filing.
Yeah,
Yes.
one is also pending. Sean, he sent me the file yesterday because of this knack work. I was not able to process it.
Yes,
Maybe the
yes, yes,
coming
yes.
Monday, I will send you through Ajit sir.
Yes, sir. Actually, we took utmost care in processing the patent application from St. Thomas Institute.
Thank you, sir. Thank you.
Yes.
Thank you so much. Thank you so much.
Thank you. Any other queries? Uh, it seems no queries, sir. So we are about to wind up the 5 days FDP session on entrepreneurship education. Let me take this opportunity to thank Mr. Shafiq S for sharing his invaluable insights on IPR and other legal aspects. Thank you so much, sir. Thank you for your time, expertise, and thoughtful delivery of the session. Thank you, sir.
Thank you, thank you.
May I take this opportunity to thank each one of you for joining us tonight. Thank you for your time. And the feedback link will be shared in a while in the group. Please do fill the same. The certificate for the same will be shared within Wednesday. Kindly wait till Wednesday. Thank you all. Thank you, Shafiq sir. Thank you.
Thank you once again. Thank you,
Thank
Sabi.
you. Thank you,
Thank you
sir.
so
Thank
much.
you very much, sir. Thank you very much for giving me the opportunity
Yeah, yeah,
Thank you,
to
yeah.
sir.
talk for you.
I want you to be in our campus one day.
Sure, sir.
We can organize one patent clinic or patent boutique.
Yes, sir.
Yeah.
I'm happy only, sir. I will come soon.
Okay, 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 sir.
Okay,
Okay.
sir.
Thank you
Okay,
so
sir.
much.
Okay. Thank you.
Good
Thank
night.
you, sir. Thank you, sir. Good night, sir. Good night, sir. Thank you,
Thank
Vipin,
you.
sir.
Good night.
Regards to our family.
Sure, sir. Sure, sir. Thank you.
Okay.
Thank you all. Good night.